I'm struck as I'm listening to our speakers today, I'm struck by the sense of community building. There's a theme that pervades everything that we're hearing today, that building of community that Donna talked about as she was reaching out with each piece and building a community between herself alone in the studio and other women out there, whether they're artists or not. And the community of hackers and the community in the digital world that Kiki works with, and that whole arena and element and how that community works. And I think in light of the last 24 hours, building community is not a bad way to be. I think it's so difficult to make sense of things that happen in the world sometimes. But there's one thing I do know, is that art is the opposite of what happened in Paris yesterday. And I also appreciate the fact that Kiki was here and was able to do what she did, and she's got family there. And speaking of community and making sense of the world, and sometimes in an out-of-control kind of world, and the kinds of constraints that we impose upon ourselves in order to keep peace, to keep to the law, to keep a sense in our lives of what's right and what's wrong, especially in the digital age where we can barely keep up with all the technological change, and that's where the law steps in, where it's been for centuries, and where it'll continue to be. And today we are so lucky to have with us Connie Mableson, who's graciously given her time to come and speak with us today. Connie's a professor at the Sandra Day O'Connor School of Law. She was voted one of the top 10 intellectual property lawyers in Arizona. In her practice, she emphasizes intellectual property, copyright, trademark, specifically in the fields of arts and entertainment. So she is absolutely the person we most want to hear from today, and I'm very pleased to introduce her. Connie?
Thank you all so much for having me, and hello to our online viewers who are watching the live stream. Would anyone object if I took my shoes off? I don't think so. This is what I'm looking forward to, the day when I can 3D print matching shoes, right? That are much more comfortable than these ones. Wow. Hard to follow two great presentations, especially on a legal matter, right? So we're going to try to make this as interesting as possible. And we're talking about today, obviously, all these new frontiers and these challenges that are facing visual artists. I have to give you the disclaimer, you can read it on your own. And how to reach me. I also am easily accessible. If you have questions about anything, give me a call, shoot me an email. I'm here, I'm a resource. I promote women, I promote the arts. I'm very interested in building strong communities around, especially women in the arts. So call me if you got a question about anything. I ran across this the other day. I just thought it was hilarious. I'm not sure there's any truth to this. I love the testimonials. I'm 60 and I'm dating a 20-year-old. Yeah, and I get invited to all the best parties. But what you also get as an artist are a lot of challenges. Obviously the challenge of just getting the art done and having the discipline to do that. But challenges in the digital environment as well. And so today we're going to cover kind of three basic areas in the time that's allotted. We're going to run through these pretty quickly. Copyright basics. I always like to give artists, again, kind of a primer on where we are in copyright law, because as a visual artist, that's where your rights come from, essentially from copyright law. And copyright law is the law that's going to answer a lot of these questions, especially about Kiki's 3D printing. We're also going to talk about how do you remove those infringing copies of your work that are on the internet? How do you get them off the internet? And we could spend hours on that, but we're going to just do this in a very abbreviated way to show you there is hope for getting those infringing copies of your images, of your artwork off the internet. And then thirdly, I wanted to talk a little bit about legacy planning. I think it's one of those things we normally don't like to talk about, but as artists, because copyright protection is so long, you may have a very valuable estate for your heirs, and you want to make it very easy on your heirs to commercialize that estate if in fact it does have value in the future. And so we're going to talk about that. But let's start with some basics on copyright law. Copyright is a federal law. That means it applies to everybody in every state, no matter where you live. And copyright is actually found in the Constitution of the United States. And it protects all kinds of works. Number 5 there are the types of works that apply to you: pictorial, graphic, and sculptural works. We call those the visual arts, okay? It protects, and these are the key words, original works of authorship. And what is an original? Was asked by a member of the audience just a few minutes ago. We'll talk about that. But it really protects what's called original expression. Those are the words we always think about when we talk about copyright. And it protects not what's swimming around in your mind as far as your next piece, but it protects when you get it out of your head and you put it on paint, on canvas, when you actually create the sculpture. That's when you have copyright protection. So copyright doesn't protect ideas in your head. It only protects the expression of those ideas in a tangible form that can be perceived by a human being, okay? If I can see it or I can hear it, there's copyright protection, okay? And visual arts are an art that you can see as soon as it is in a form that I can see, okay? So just think about things that aren't protected under copyright law. Works that haven't been fixed. Your next artwork, your next sculpture that's going around in your head. That's not protected because it's just an idea in your head. You actually have to do the sculpture, paint the painting to make it protected by copyright law. Titles, names, short phrases, book titles, song titles, mere listing of ingredients, those aren't protectable because they're not original enough. Recipes aren't protectable because there's only so many ingredients out there and there's only so many to mix them or blend them and bake them, so recipes aren't original. Works that consist entirely of information that are common property, height and weight charts, the phone book, those sorts of things aren't protectable. Facts are not protectable, and useful objects are not protectable. So my shoe, when I 3D print my shoe, that's a useful object. I can't copyright the shoe. I might be able to patent the design if it's novel, but maybe I put some nice artwork on the side of my shoe. That artwork I can protect, but I can't protect that artwork on the shoe. That artwork itself I can protect separately, okay? Ideas aren't protected. The actual expression of that sculpture, the actual visual art as it comes out of your head onto canvas is what is created. And it's created at the time it comes out onto canvas or it comes into a sculpture. And as the owner, because you're the author of that work, you have 5 copyright rights. It's kind of like the Bill of Rights in the Constitution. These are copyright rights that you have as the author, as the owner of that copyright. And if anybody wants to use your work or wants to be able to, exploit's a good word, exploit your work, they have to get your permission to do it. Okay, and here are your 5 rights. You have the right to say who gets to make a copy of your painting, a copy of your sculptural work. You have the right to prepare a derivative, sculptural multiples, prints, posters, placemats, coffee mugs, anything that shows your artwork is a derivative of your original artwork, and you have the right to that as well. So if I want to make placemats out of your painting, I have to get the author your approval to do that. I have to get licensed to do that, and that will come with a payment to you if you so choose, and it will come with a lot of quality control provisions as well. I can't change the original artwork. It has to be done in a certain type of placemat quality. It has to be offered at a certain price, et cetera, et cetera. Preparing derivative works is a really, really, really strong right under copyright law. In the non-visual artist sense, probably the best example of an exploitation of derivative rights would be the Harry Potter books. They came out as books. They went to movie, then all the merchandise around Harry Potter, right? Now there's a theme park that's just a Harry Potter theme park. She owns all of those because they derive from the original book. Same thing with you. Everything that derives from your original paintings, everything that derives from your sculptural works, you have a right to that, a right to own and control those works. You have the right to distribute copies. So somebody might be able to make a copy for a single print of your work, but you have the right to say who can distribute the copies as well. If the work is capable of being performed, then you have the right to control the performance of it. And the big one, of course, is the right to display the work publicly. Again, those belong to you, the author, and those are valuable rights because it's those rights and it's from those rights that give you the ability to stop people from copying. Okay, so far so good. Any questions? All right, great. Yes.
Do you actually need the copyright symbol?
Yeah. We'll get, you do. The question was for the people listening to the streaming, do you need the copyright symbol? The answer is no, you don't. You don't lose the copyright by not including the symbol on the work. However, it's really easy to do. It doesn't have to be on the front of the piece. It can be on the back of the piece. And you should put the circle C, your name, and the date of completion, which is usually the year of completion. And what that does is it lets the world know that you are asserting your copyrights. And it also means if somebody copies your artwork, it's intentional because there is that notice on there that you are claiming copyright protection. So I always advise all my visual artists, yeah, put it on the back of your work, on the underside of your work, but you've got to put it somewhere. In a photograph, you can put it anywhere in a photograph that's aesthetically works for the photograph. But if you don't do that, you don't lose your copyright.
Can that just be a handwritten little C in the circle?
Yeah, absolutely. C in a circle, you can put copyright, C-O-P-Y-R, your name, and the date, which is year, the date of completion. That's the proper. But again, if you leave any of those components off, you don't lose your copyright, but you lose the opportunity to claim intentional infringement because they're not necessarily aware is the defense. Yes, question?
On the display.
Right.
So you sell your paintings, and let's say the painting goes into a museum's collection.
Right.
Do they then have to contact the artist or the estate in order to display that?
Yeah, usually what happens is if you send your into a museum, it comes with an actual form that gives them those rights to display. So when you send something to a museum and it's there on a permanent collection basis.
Somebody you sold the painting to.
Yeah, we're going to get to that under the first cell doctrine in about 3 slides. Any other questions at this point? It's kind of hard to see. I don't see any. Yes, sir, down there.
I'm widowed and my wife wrote books and music, and there wasn't a provision made for, she had them copywritten, but there wasn't a provision for them to be turned over to me, or am I in control of her copyright?
Yeah, we'll talk about that in our 3rd section on legacy planning. What happens to your copyrights, yours, your wife's, your spouse's, when you pass? Yeah. Okay, I think that's it. All right, let's move on. This is just another chart that gives you that. Let's talk about the term and the duration of the copyright. This is where it gets really interesting. Your date of death plus 70 years. That's how long the copyright lasts in your works. Your date of death plus 70 years. Well, that's a couple generations beyond you who can still take advantage of the copyright and still have those rights. And that's why it's important when we talk about legacy planning. If you're a very successful artist now, great. You've given a legacy to build on. If you're not, you never know what might happen if your heirs are given the proper rights to exploit, market your drawing. You just never know, right? I mean, I just sold some music I recorded back 30 years ago to a vintage music house. It's a little discouraging, but time marches on, right? Okay. So it's a very, very long time, 70 years after your death. So I want to talk next about the question somebody just had here. It's called the first sale doctrine. And this says that you can sell the painting without selling the copyright rights. And generally that's what you do, because in order to transfer the 5 copyright rights, you have to do it in writing. So a sale of your work does not usually come with the sale of the underlying copyrights, okay? So just because I might have your painting in my house doesn't mean I can make prints off that painting. You still have the right to do that. If somebody wants to buy the copyrights in addition to the original piece, the price will go up because those 5 rights have value to you, and if somebody wants to buy one of those 5 rights, you're going to be asking a lot more money for it, especially if the right they want to buy is the right to make copies and distribute copies, right? So in order for you to transfer your copyrights on sale of your works, they have to be in writing. And the owner of that work simply owns the work. It's like when you buy a CD, assuming anybody buys CDs anymore. If you buy a CD, you don't own the copyrights to those songs and to those recordings. You just own the right to have that CD. You buy a book, it doesn't mean you own the copyright to that book. It just means you own that copy of that book. And the same is true here. You sell a painting, you sell a sculptural, you sell whatever it is that you've made, whatever your work is. It does not go along with the copyrights. You retain those copyrights. Any questions about that? Yes, ma'am.
Does it matter if it's for purchase or just for use? So let's say someone buys your painting, their home is photographed for a magazine, and the painting is in a magazine. I don't mind when that happens, it's good PR, but I'm saying, but there's no profit to be made there.
Yeah, we would probably call that a fair use exception under the law. You have the right to use copyrighted material as long as it transforms that work somehow. That's a case-by-case basis. In that case, you're a smart artist because that's more exposure for your work. But you could get very technical on them, and you could say, I didn't give you the right to display that in your house in a photograph, and you need to pixelate it away. So there's you want to look at every single one of those with the idea, is this really benefiting me? Is this hurting me? Yeah, that's a good question. Any other questions at this point? Yes, sir.
Someone brings a photograph that they took and has you paint it for them. They own the copyright to the photograph, therefore you cannot make copies of what you painted for them?
Yeah, let's save that question for towards the end, okay? That sounds more like a little personal advice, but we'll talk about that, okay? Okay. So, summary of copyright law. It's a federal law. The author is the owner unless copyrights are transferred in writing. You have 5 exclusive rights. The term is the life of your author, your life, plus 70 years. And any copyrighted material requires permission by the owner or the author for it to be copied, distributed, performed, displayed, and for derivative rights to come out of that. Okay, any other questions? Yes, ma'am.
If the term of the copyright is the life of the author plus 70 years?
Yes.
What's the purpose of putting the date with the copyright symbol?
Well, you put the date because that's a date that basically it's either published or unpublished. And I want to know the date because I want to know when you filed your copyright registration. That will tell me how much damages you're entitled to for purposes of infringement, right? And so that kind of raises another question. Do I have to file a copyright application with the Library of Congress? No, you don't. You have that copyright as soon as it comes out of your head and is on the canvas or is in the sculpture. However, the lawyers will tell you, yeah, please do send in your copyright application. You can combine multiple visual arts into groups, and you can use one copyright form for $55 on an online filing for those works. You want to make sure, though, that you identify what works are being copyrighted under one form, Okay, just keep records of that. And then you'll submit photographs of your works to support that. You can do it all online, copyright.gov. It's called ECO, Electronic Copyright Office. You simply have to create an account. The process itself is a little clunky. It's not as intuitive as they'd like to make you think it is, but it's not horrible. Once you do it once, you'll get it. Yes, sir.
Yes. Is it easier now to find, if you had, say some poetry copyrighted years ago and you had a number of them, is it easier now to find online what you already have had copyrighted?
Yeah, the question for the audience on the stream who may not have heard that question, is it easy to search the Copyright Office now for copyrights that you may have filed in the past? And the answer is yes and no. You can do a copyright search. You can search by title, you can search by author, it's I don't think it's DOS based, but it sure feels like it's DOS based. It's clunky, it's hard, you have to go into individual years sometimes. It takes a while, but it can be done.
Thank you.
Yep, copyright.gov, and there'll be a separate place to search. And so the reason why we file a copyright, you don't have to under the law because you have copyright protection, but you file a copyright application for a number of reasons. First, when somebody is infringing your work, copying your work, and you see it up online, it is so much nicer when I can send them an actual form from the government, right? It looks a lot more official. Secondly, you file your copyright 3 months after you publish your work. Publish your work means making it available to the public, putting it up online, showing it in a gallery. If you file within 3 months after you publish your work, you're entitled to what are called statutory damages for copyright infringement. That means that a judge will award you between $750,000 up to $100,000 per infringement. If you don't get statutory damages, you have to prove your actual damages. How much did the infringer make off selling copies of your work? And that's just a whole heck of a lot harder and a lot more expensive. So if you're registering copyrights, please do it 3 months after publication so you get in that statutory damages window. And it makes your case 1,000 times easier for the lawyers to actually be successful in getting your works down and maybe getting some money back for that as well. Yes?
Is that 3 months or more, or exactly 3 months?
No, under 90 days, under 3 months, within 3 months. Yeah, within 3 months, yeah. Now again, if you don't happen to get within the 3 months, don't sweat it, still file it. It's just, it may be a little bit harder to prove actual damages because you have to get copies of the infringer's records on that, and that usually requires a lawsuit. They're not going to usually cough that up right away. Yes, ma'am.
Do these laws apply internationally?
Mostly they do. Most countries are signatories to what's called the Berne Convention, and they basically will give full faith and credit to the laws of each country's copyright. It can mean that there are some issues as between which country says what copyright happened first, but generally speaking, you have international protection, yes, on signatory countries, which is most of the civilized world, most of the Western world. Okay, any other questions? All right. So from there, we'll move on with this very basic understanding of copyright law to talk about a common problem, and that is people using either photographs of your work or making multiples of your work without your permission. Has this happened to anyone? Have you had your work show up on somebody else's website without your knowledge, approval, permission? Yeah, I see about half of you have had that issue. It's very, very common. If you can just, right-click on a mouse and copy something and put it into your website, people are going to do that. People are lazy. That's about half of my practice is taking down infringing copies of whatever it might be off of the web. And there's a way to do that. And we're going to kind of look at the abbreviated version for doing that. First of all, we need to talk about infringement. So infringement is basically theft or stealing in copyright language. Somebody has infringed your work if they're using your work without your permission, or they're using one of the 5 rights that you have without your permission. And an infringer can be a direct infringer. That is the person who actually made the copy and uploaded it to their website, okay? They're the ones that went ahead and committed the crime, if you will. But there can also be contributory infringers, okay? And that would be by an entity displaying the infringing work. So let's say somebody uploads a photograph of one of your works to Facebook. Facebook is a contributory infringer because their computers and their service is hosting that image. Okay, so they are facilitating that infringement because it's their system and their computers and their software that is facilitating the ability for this person to have copied and use your image on their website. So not only does the direct infringer have liability, but anybody that's facilitating that infringement is as well.
So you mean if somebody shares an image on Facebook?
The fact that they uploaded it without your permission, and assuming you care that they did that, they're using it in a manner that's taking away the monetary value of what you're doing, or they've changed it, or you just don't want people using your pictures on their funky website. I mean, yeah. So the person that actually used that photo, copied that photo, is the direct infringer. Then the contributory infringer would be perhaps the owner of the website, Facebook, who's hosting that picture on their computer services, and whoever might be hosting that website. So if you are hosting your website with GoDaddy, GoDaddy could be a contributory infringer because, again, it's their hosting services. So there could be several infringers along the way that have liability for illegally using your picture or your photograph or your image. Is there a question? Yes, in front.
If you post your painting on Facebook and then someone else shares it, is that implied permission?
It could be implied permission. The question was, if you post your photograph of your work on Facebook and somebody else shares that, is that infringement? Technically, it's infringement because you didn't give them the right to do that. But are you going to really mind if they share it? No. Yeah, and you can adjust your settings as well. But if you haven't done that and that actually happens, most people wouldn't care because that, what we like to do, and we'll talk about this, maybe we can talk about it now, is what you want to do is watermark your photographs so that it's very clear when someone copies and pastes, the watermark goes right along with it, and it's very clear that, and that watermark usually has a copyright notice, your name, and I usually say put a contact, put a phone number, put a website, so that it's very clear as to where it came from. I have many photographers who also put something in the photograph that is not necessarily, you can't visibly see it, to identify the photograph, and that lets them know where it was copied from. Or they put something in the metadata on the photograph, and there's plenty of programs to do that. If you watermark, you really help yourself out in terms of discouraging people from taking that image. They'll just go to another image that isn't watermarked. Yes, ma'am.
So we were thinking of that, and it was one of our questions, thank you. And we were wondering, there are some free apps for watermarking, are those okay?
Yeah, absolutely. As it doesn't matter if they're free; they're given to you on the basis that you can use that without infringing their code. But absolutely, yeah.
Something to look for in a watermark app that we should.
Well, I think you want to make sure that you have the ability in the Watermark app to put contact information, because again, you want to trace where that came. Where did they take it from? And you might have pictures of your works out across a wide variety of websites, but you want to have information upon that, who you are and how to contact you. Right, so that it's not just, whose is this? This is mine, that's what my watermark is saying here. Yeah. Okay, all right. So back to internet infringement. So if there is a picture on Facebook that you didn't put on Facebook, the person that uploaded it is a direct infringer. Facebook is a contributory infringer, and if somebody is hosting Facebook servers other than Facebook, they are a contributory infringer. So how do we get this down off of Facebook or off of whatever website? First of all, you want to find out where the infringing work, which is work that has been posted and displayed without your permission, where is that? What is the URL, the uniform resource located? What is the web address where your infringing work is located, okay? And then you want to find out who owns that website, okay? Who's the owner of the website who's got my work being infringed? Who is that? And the place to go to do that, there's a number of places, but the easy place to go is whois.net. Whois.net. And you type in the URL, okay? So the name of the website where it appears, okay? You probably don't need to do that for Facebook, because we all know it's Facebook. But if somebody has it on a private non-Facebook, non-social media website, they're using your image as a background image for their website banner or their website headers, this will tell you who they are, okay? And if it says that they are registered by GoDaddy, this is where they registered their domain, then you're going to go to GoDaddy and do a who is search at GoDaddy, and the records will come up as to who owns that website. So now you know who they are. There'll be an address and there'll be a phone number. Now the only time it won't be there is if they've had it privately protected and paid an extra fee to do that. But that doesn't matter, because you still know a couple of things. You go to the infringing website and you check to see what that infringing website says about copyright violations. And an example I'm going to use, and I don't know these people, they're, as far as I know, very legal, Gallery Direct. Has anybody worked with Gallery Direct? Does anybody have any prints that are being made of your works from Gallery Direct? Okay. So here's Gallery Direct's homepage. And what they do is they allow people to order copies, print on demand, canvas on demand works, if you will, of your original images. And so what if somebody claims that your work is theirs and they get Gallery Direct to put it into their catalog, and then now people can buy your images, but somebody else is getting paid for that? You would go to the gallerydirect.com website. You'd find their terms of use. Now here you can't see it. It's right here. Terms of use. Terms of use are generally at the bottom, at the very, 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 very bottom, right? Because nobody reads terms of use except the lawyers. And the terms of use will typically have, if you have an issue with copyright or trademark, here's who you need to send it to. And here is the Gallery Direct infringement policy, and you send a notice of infringement to them, okay? And the notice of infringement should state the following. Very simple. Identify your original work. Here's my original work with my watermark on it, hopefully, or not. You want to tell them where the infringement is located on their website, on this page, and give a copy of the URL address at the top. Let them know where it is on their website. The name of the infringer, if you have it. your contact information, a sworn statement in number 5 there, and your electronic or physical signature. You can just a signed email. You can put this in an email. And what you do is then you send this notice of claimed infringement to whoever the terms of use say you need to send it to. And by law, they have to remove that infringing work from their website as reasonably and expeditiously as possible. It will come down. Then they give the person who actually posted the infringing photograph an opportunity to say whether or not they actually own that work. If they do actually own the work and you're wrong, which is kind of hard to believe, then they have an opportunity to say, no, that is my original work. That is not, that person's wrong. That's not her work. And in which case, the website has to put it back up. Okay? Now, usually in a blatant infringement case, it comes down, it stays down, because it's clear, especially on works of visual arts. It's not unclear who the owner is. You're the owner. It's a visual art piece. It's, you know, it's pretty plain, it's pretty simple. Music's a little tougher to take down, but with visual artists, it's a little easier to take down because you can prove you have a whole body of work. This is your style. You might have a copyright form, et cetera, et cetera. We also send these notices to the web host, whoever is hosting the website, and that's usually where it comes down. You send it not only to the actual infringing website, but whoever is hosting that website. Do you understand? You have a website, and it might be hosted on servers that you own, but probably it's not. My website's hosted by GoDaddy. Most people have websites that are hosted by some hosting company. You send that cease and desist letter to that hosting company, they'll take it down, even if the original infringer doesn't, or you don't know who the original infringer is, and that will come down. It just will. And it's really as easy as that. You just have to identify who is the infringing URL, find out what their terms and policies are as to where send the notice, find out who's hosting it, which you can do through the who is search, send them that same letter. You can do this all through the email, and as long as your notice of infringement contains these items, you will get that taken down almost immediately. I probably do 20 of these a month, easily. It's all to the same people, for the most part, Facebook, Amazon, you know, all of the biggies. But even on the small websites that have no idea what they're doing and are clueless, I send it to them, but I usually send it to their host. And their host knows that they got to take it down, or the host will have contributory liability, which means their whole business will go under because I can sue them for contributory infringement. And that would probably put them out of business, just in defending it. Okay, yes, question right here.
What are the parameters, like what if it's just cropped or?
I'm sorry, what if it's what?
What are the parameters for judging whether it's still your work? What if it's cropped a certain way? Or if I've had things that have been slightly colored a different way?
Right. So the question is, what if your work has been cropped or colored or modified in some fashion? It's still your work. It's still protected by copyright law. And you also own the derivatives of that work. And so just because it's been changed or transformed might give somebody a fair use defense. Oh, we've transformed it so it's no longer her original and therefore we get to use it. No, don't buy that for a minute. It's still yours, and they're using it as a basis over which they're modifying it. It's still your work unless they've transformed it to the point where even you can't recognize it. Yeah. All right, we had one in the back, yes.
What if someone like physically recreates your work and then they put a picture of the one that they painted on there? But, you know, maybe they're good enough to create it, you know, exactly like you did, colors
Right.
and everything.
So the question is, somebody has taken your work and repainted it or resculptured it. As long as they haven't completely transformed it, it's still an unauthorized copy. They might argue, well, the style's a little different, or I used a pencil instead of something else, a paintbrush or something. But the idea is that there's an intent there. And unless they've really transitioned that and transformed, is the word, that into a completely different product, that's called fair use, then it is still copyright infringement. And I probably should tell you, I am pro-copyright rights. I am very strong about copyright rights. I represent artists and creatives all day long, and so other people up here might say, "Oh, it's fair use and whatever." I say, no. You start with the law on your side, and you argue the law all day long. And if somebody want to argue fair use as a defense, okay, let them. But you start with the proposition. Don't give it away to begin with. Okay. Yes, ma'am.
I found a painting of mine on a website that was high image resolution downloads, and then someone had it in a senior lecture on waterfalls. I wrote to them and told them, you didn't ask my permission for this. And I said, what is this about? And I never got an answer, and
Yes.
I'm real happy with that.
So the audience member, for those listening to the stream, said that somebody had used an image of one of your works in a presentation.
And also it was double leveled. It was also a website first that had high resolution downloads.
Okay, right.
So that was it, and then the secondary was that it was on this presentation.
Okay. So the presentation, that may have been fair use, only because they weren't trying to sell duplicates or replicates of it, and it didn't change, or, as long as they didn't do anything to it in the presentation that you would find maybe morally offensive, or I'm more concerned about them using it on the website itself, because people don't use images on websites. They use them because they think it'll attract more visitors. Right? They use it to enhance the value of their website. So they wouldn't use it if they didn't think it brought, it wasn't going to bring value. They're using it because it will bring value to their website. So that's the one I would be more concerned about, is taking it down. A senior presentation on waterfalls, I might contact the guy and say, I want attribution, and I want you in your future presentations, if you're going to use my work, I want my website on there, how people can order copies.
Address, so I feel like only advertising.
Exactly, and again, encourage you. You're welcome to use my picture in your presentation. Just put out some information about who I am and copies are available or something. If that's, turn it into an opportunity to sell more, create more exposure for yourself. That's kind of how I look at it in those kinds of cases. It's not worth getting too excited about, but the website is. Yeah. Yes, ma'am.
I just wanted to share that there's an app called Reverse Seeds. There's an extra on the end, and you can search your images online. So if you have an image that's been published a lot or in magazines and you know it's out there, you can search it and find where it is.
What's the name of that app again?
It's the word reverse.
Reverse.
With an extra E on the end, and the little symbol is like a little magnifying glass.
Okay, reverse with an extra E on the end.com probably has an app that you can use to help find things. Yeah. Yeah, that's great to know. Any other questions? Yes, ma'am.
I had, someone had copied my signature on a painting that I did not do.
Oh my goodness. Oh my goodness.
Okay, so the issue is someone had copied this woman's signature and put it on a painting that was not hers. So they were passing off the painting as yours. Yes. That invokes a number of different laws. What state do you live in? Oh, you're in Arizona. Okay. Well, a signature is a trademark. And so there's a trademark violation there, what we call passing off. It's unfair competition. They're passing off as good as yours. It's like buying a fake Coach bag. It's buying a fake whoever you are painting. And you have rights of publicity that include the rights to your persona and your indicia of persona, which is your signature is one of them as a visual artist. So there's all kinds of problems going on there. They've got copyright, trademark, and rights of publicity issues to deal with. Did you find out who did it?
No, I have not been able to. But it was in an auction, and a collector purchased it thinking it was mine.
Yeah.
Which was disconcerting because it was really a terrible painting.
Well, yeah, right? That's why, you know, the quality of your painting and the distinction of who you are, you know what, yeah. That's the problem. Well, the auction house needs to be, you know, they didn't properly vet it. They don't know what they're doing, obviously, in the auction house. Yeah, I'm sorry to hear that. Yeah, absolutely. That's fraud. That's big time fraud. Yeah, we don't like to see that happen at all. Oh, I'm sorry about that. Yeah, okay, any other questions? One more on this, yeah.
On that same order, I had, my niece keeps an eye out on eBay.
Yeah.
And she's contacted me a couple of times when there were pieces coming up that were not my paintings, but were being sold as my work. And I don't know that they had a signature or not, but they were not mine.
Right.
And so she requested that they take them immediately down, and one time they did, and one time they did not.
Yeah. Well, that's passing off. That's counterfeiting. Is really what is like, you know, selling a Coach bag and it's not really a Coach bag.
Same kind of thing.
Exactly. Yeah, exactly. All right, I'm giving the nod here that I need to move on. I'd be happy to answer questions afterwards. So the good news is here you can get it off the internet fairly easily. Okay, it is possible to do. I want to just talk real quick about 3D printing because the Kiki's demonstration was awesome. What it does right now is it presents problems for sculptural artists. It's another way for sculptural artists to get ripped off. Now, it doesn't mean your big pieces will get ripped off because we're not that big format yet, but technology moves really, really fast. And I'm hoping within my lifetime, I'll be able to, you know, eat out of my Star Trek food replicator and my shoes. And so with the public art installations that are now getting 3D copied, there we go. Yeah, it just went quiet. That is a problem. And to what extent changes are made to your original in that 3D imaging process or afterwards in the code, those are all potentially troublesome for primarily sculptural artists because it's 3D and not 2D. But we've got a lot of work to do. The law has a lot of work to do on that when it starts coming into being. Okay, let's go on then and talk about death. Okay, again, copyright law lasts 70 years after you pass. And I have been called on numerous occasions out to the hospital bed of a dying prolific artist to be there to advise what they should put in their will. And that is so rough. I'd rather do it while they're still alive and still vibrant and not at the last minute. And so what you want to do is some legacy planning. And as much as we don't like talking about it, this really isn't for you because you'll be gone. This is really for your relatives, for the people you care about, for the people you leave behind. So the first thing you really should do is make an inventory. And if you haven't done that, you need to start doing it. And what do you inventory? Your originals. Where are they? Who you sold them to? Did you sell the copyrights with it? Where are they? Are they online? Which print houses have you given permission to? Which websites have you given permission to? All of that digital information, as well as if you filed copyrights for each of the pieces. If so, you're going to want to do a great big spreadsheet or some kind of table or some way of organizing this information. I also encourage artists to keep records of sales so that it will help to value what your heirs or your devisees are going to price. How are they going to price this? How would they possibly know based on prior sales that have been made? If you have pieces on loans to galleries, pieces on loans to museums, you need to put that in there. Because this is all in your head, and you might have written it down on little, notes here and there, but you really need to organize it in a way that your heirs can appreciate and understand. So how do you create that artistic legacy? Well, if you don't make a plan and you die without a will, the state in which you live tells you where those paintings or where those sculptural works and those copyrights will go, okay? It's called intestate succession, and generally it goes down to kids if you don't have any kids, up to parents if you don't have any parents, out to siblings. But you really want to have some kind of a plan in place, such as a will. And even if the Cheshire Cat gets all of Lewis Carroll's copyrights and books, at least we know who gets it, and there's no huge lawsuit over who gets your pieces. And so what are your options? You've got a couple options. You can do a will. This is personal property. Copyrights are personal property. And in your will, you can say, I want this painting to go to this person, these copyrights to go here. You can do whatever you want to whoever you want it to go to, okay, all day long. It's just like a car, a boat, an automobile. It's not just like that, but you know what I mean. It's just like a piece of property that you own. You can say who gets it. Now, maybe somebody gets the painting and somebody gets the copyrights. Maybe not. It just depends. You can treat those separately, or you can devise them the same. If you don't do a will, then maybe you want to do a trust. But again, you want to do something, otherwise the state in which you live in will say who gets it all. Again, you may not be an exceptionally successful person now, but your works may be. I mean, isn't that the story of an artist's life, right? Maybe in the future it will be. So it's really important for you to plan now and put all of that information in one place that's easily accessible, and give somebody in your family or a friend access to that information so that they can get to it when you pass, because what you're doing now is valuable, and it may become even more valuable from a monetary standpoint in the future. We're still working with permissions from estates all the time. Set dressing, movie dressing. You want to use something that's still within copyright protection, you've got to get permission of the authors in set dressings or movie dressings. So it's very important. As artists, this is valuable property. It comes from your heart, it's your baby, it's your child, but it's also something that you as a legacy can pass on to friends and family. Questions? Yes, ma'am.
If you have a will with your spouse, that the surviving spouse gets the other half of the estate, does that include all of this, or does it have to be called out specifically?
Well, it's the terms of the will say that the other spouse gets everything upon your death if they live a certain 60 days after you or whatever it is. Yes, this is property just like any other property, like a car, a boat, or a house. And the actual physical paintings or sculptures are property, as well as the intangible copyrights as well. Yeah. Yes?
When you sell through a gallery, most of my galleries have not given me the names and addresses of the purchasers, which I don't know what the legality is there. Are they supposed to?
Well, gallery contracts are governed by the laws of individual states.
Okay.
And so you have to look at your state laws to see, and they're different. In every state, they're a little bit different. A lot of times, if they don't have to, it's just it's a policy. They want to keep their patrons so that you don't contract the patron directly and get a direct commission. Yeah. So a lot of times that's just kind of what you live with. But they don't sell the copyrights. You still retain those copyrights. Yeah, unless there's a specific negotiated agreement to do that. Yes. Yes, question.
Your child inherits your work and your copyrights, and let's say the 70 years is about to expire, do they have to re-register those copyrights?
No. The copyrights last for 70 years, period. You don't have to jump through any hoops. You don't have to do anything as long as there's proof of authorship.
So what about great-grandchildren and so forth? It just
However many generations happen within that 70 years after your death.
So once you register it once,
Yes.
your work is done.
Correct. There's no renewals, nothing that's necessary. After 1976, we didn't have to file renewals. Yeah, right. Yes, ma'am.
After 70 years, nobody has copyright on that?
Yes, after 70 years, there's no copyright protection, and it falls into what's called the public domain. Public domain means it's outside of copyright protection, and you don't need anybody's permission to use it, because nobody has any rights to it. Yeah. Now, to answer the gentleman's question, if the will gave the spouse all property, then that would include copyrights, include that to the books, right? So we look to the will, and what did the will say? And a lot of times in wills, there's a clause that just says, everything that I haven't listed in here, whatever that might be, goes to my husband, goes to whoever. That would include pick up the copyrights and pick up the paintings or the sculptures as well. Yes?
I really appreciate you telling me that, because this was unexpected in my life. So,
I'm sorry to hear that.
don't wait.
Yeah.
I mean, if
Yeah.
you don't have provisions, do not wait.
Yeah, especially if you have a piece or pieces that you want to go to a special person who isn't necessarily in your family or in the direct line of descendants. If it's a particularly valuable estate, we also like to put clauses in wills. Again, it's up to each state that says if anybody contests the will, then nobody gets anything and it goes to the homeless shelter or something, you know what I'm saying? There are ways to get around that. But it's property just like your jewelry, just like everything else, and if there's a special person you want it to go to, let's make that happen. Any other questions? Yes, ma'am.
I thought I heard a question, started a question back there where a person had a picture or a postcard or a photograph, and they were in a quick draw, or they were just painting from that, and then that piece has been sold.
Right.
In an auction. What is the interpretation that you have if you're actually copying something?
Right. So the question is, what happens if you recreate an image off of a postcard or an image off of another photograph or something like that? It depends how much you take. It depends what the medium is. It depends on how it's changed from the actual postcard. We have to do what we call an A/B comparison. And if there's any extra originality that was in there, so I can't give you I have to give you an it depends answer. I can't give you an absolute answer. I mean, that came up with the Obama poster. That has come up a lot of different times in a lot of different contexts. And it just depends on what do they two look like. In the Ninth Circuit, it's total concept and feel. Substantial similarity, total concept and feel. And if the total concept and feel is different, it's probably not an infringement. I mean, that's just a little bit of what that law looks like, but yeah. Yes, ma'am.
I'm a professional photographer who shoots my work for me.
Right.
And at some point over the course of the years, he mentioned that he has copyright
He
law
does.
over my image that he took.
He does, and I'm glad you brought that up. So what happens is, when a photographer, how does a photographer get copyright rights? Whoever takes the picture, actually depresses the shutter on the camera, owns the copyright. Uh-huh. Well, except the monkey, yeah. There's this recent case where there was a monkey out, I don't know, in Borneo or somewhere, and he took a selfie of himself. And PETA is claiming on behalf of the monkey that the monkey owns the photograph. So the Copyright Office issued a clarification that only humans can own copyrights. And now there's apparently a big problem over, well, was this the on behalf of such and such monkey, was that the monkey who took the selfie? So now they're not even sure it's the same monkey who took the selfie. It doesn't matter. So your photographer owns the photographs. and he is granting you the right, or she is granting you the right to use those photographs. So technically, when you're sending your cease and desist takedown notices, it's on behalf of the photographer who actually owns the copyright. But that's getting too confusing. I think that as long as they understand it's an infringing image, they'll remove it. And if you don't have the cooperation of your photographer, it can sometimes be a little dicey. But most of the times, they're going to take that image down because there's somebody out there claiming an infringement, and nobody wants to be sued for copyright infringement. No. Nope.
Are they able to take my image and utilize it in a book that they're publishing on their own?
The photographer?
Yeah.
Technically, they would. Yeah. Now, they don't have the permission to display your image, so you could get them on that. Okay, I gave you permission to take a picture of this for my purposes, not for your purposes of displaying it in a book that goes back to you. Okay, I don't give you display, that's not what this is. Technically they can, but typically photographers are usually pretty good. They understand this because they're infringed on all the time.
Well, he's not looking to.
No, most of them aren't.
It's not that. It's
No.
just the thing that sat in my head. I'm like,
Yeah.
well, who owns my painting?
Right. Yeah, you own the subject matter. He owns the actual image. But he's gonna want to get your permission. They normally, the legitimate ones do. They're not usually in trouble. That's like you never own your wedding pictures. Yeah, you can't buy them. You can own the prints, but not the copyright. So, oh boy, and with that, 5 hands went up. Yes, ma'am.
Is there a waiver or contractual kind of thing that you could give to your photographer that would preclude the copyright?
You could. The question is, will your photographer sign something? 9 out of 10 won't. That's just the photography law, and that's just kind of ingrained in photography law because they want attribution. Most photographers want attribution above all. So 9 times out of 10, your real good photographers aren't going to give you that. Yeah. Okay. Any other questions? I'm seeing here my time. I got 1 minute. Yes, ma'am.
So does the photographer have the right to make prints from that image?
No, Yeah, I would argue that they have the right. They're going to argue they do, but they don't have the right to display the underlying material. Yeah, we don't run into that too much because photographers are usually pretty good. It's such a self-contained environment, but it could become a problem. But it hasn't been. That's an age-old problem. It hasn't kind of cropped its ugly head up. Any other questions? All right, well, I hope I've helped you today. Thank you so much.